My name is Selwyn Romilly. I'm retired. Before retirement, I was a provincial court judge for 21 years and a Supreme Court judge for 19 years. I went to the University of British Columbia, graduated from this law school. Quite frankly, law school was a tough time for me. I didn't like it at all. I don't know how many fun times I had. I was the only black in law school. This was the 60s when there was a lot of turmoil in the United States. And in Canada, it wasn't much better. There were no dogs and hoses, but it was difficult for us to get a job. You know, people like Lena Horne couldn't get accommodation in some of the hotels. It was pretty rough. And 3 years before I came into law school, there were three Trinidadians who came into law school, and they either failed or were failed. So the pressure was intense. And were it not for the aid of some good friends in law school, I don't think I would have made it. But for me, it was one of the toughest times in my life, that's going through law school. The prospect of becoming a judge wasn't something I was even thinking of, because there were very, very few, but there were no black judges, there were no interracial judges. It was a white bench. I didn't think about it. I happened to be practicing up in Smithers, and how I got to Smithers is something else, another story. But I was doing very, very well financially. As a young guy, a new family, and they weren't paying that much, quite frankly, and I just wasn't interested. After the third time they asked me, I decided I'll do it. And the only reason I got it was because there was no one else. There were very few lawyers in those days. Most of my colleagues went to big firms in Vancouver, but I couldn't get articles in Vancouver, and this is what sent me up north. So people of, if I might say, my caliber didn't usually go north. So the NDP government came in and they decided that they wanted to get rid of all the lay magistrates, and they wanted a legally trained bench. And there weren't too many up there. So that's why I was asked. It's not because I was the brightest or the best. I just happened to be there, and they asked. But I finally decided to change, decided to accept it after I spoke to my dad, and he convinced me that I should. Being a judge, or how to be a judge, is something I didn't even think of. I didn't think it was a possibility that I could be a judge. I didn't even think about it. So I had role models in law, in the practice of law and what have you, but I didn't even consider role models on the bench. It's getting better, but for quite a while it was very, it was Anglo-Saxon male bastion. You know, you got people like Mary Southern, the Honourable Mary Southern, and Patricia Proudfoot, and it's only recently that they were appointed to the bench. You got people like Mary Ellen Boyd and a few of the others who were appointed. But that's when they decided that, okay, fine, they're going to allow a few in. Now you have a robust, I should say, amount of women on the bench. Still, you don't have 50-50. Minorities, since the Liberal government got in, it's been a little better. But in the provincial sphere, the Provincial Court of British Columbia led the way. They had no problem with diversity. The Superior Court, on the other hand, seemed to have had a problem for quite a while. But it's a lot better now than it was before. Still not the best. When I started as a judge, about 60% of the people pled guilty, and the others were set for trial. and eventually some of them would plead guilty, as some of them were trials. The trials were not as long as they are now. I happened to be presiding over 2 conspiracy trials when I was on the provincial court, and these were huge trials. I remember calling counsel in, and there were quite a few counsel, and asking them if they were satisfied, if they got enough disclosure and what have you, and they were all satisfied with it. And then the trial started, and this was around 1990, and that's when most of the charter issues started being resolved by the Supreme Court of Canada. The disclosure suddenly became, inadequate, and there were all these charter issues that we never had to deal with before. So what was perhaps a month-long or 2-month-long trial ended up with almost a year-long trial. I did one case called Regina versus Wilder when I was on the Supreme Court. The guy was unrepresented by counsel, and this thing took about 9 months. I did a health injury trial that took 2 years. That sort of stuff, and the charter is responsible for the prolongation of these trials, and it's perhaps unfortunate, and things are changing. When the charter was promulgated, the Supreme Court of Canada had no precedents to follow because the charter was unique, and they refused to follow American jurisprudence. In some areas, American jurisprudence has covered some of the areas covered by the charter. So they kept making it up. And what you had, for instance, was a case like, in the case of unreasonable delay, a whole bunch of jurisprudence that developed by the Supreme Court of Canada, and then they changed that about 3 or 4 years ago. So, and then with respect to Section 24(2) of the Charter, there's a kind of balancing process that you have to go through if there's a charter breach to see whether the evidence should be excluded or not. Well, they changed that again in a case called Grant. Before, if it was conscriptive evidence, it automatically went out. If it was non-conscriptive evidence, like you make a search and you find a door or stolen brooch or whatever it is, that usually went in. But now you have this balancing process under Grant. And with the balancing process, you're not sure how it's going to go. If I find a charter breach and I go through that balancing process, I could write 2 judgments, one letting it in and one excluding it. So the incentive for people to plead not guilty is great. So we have a problem. So I have always taken the position that, I write my judgments as soon as the case is over. Sometimes I start writing it in the middle of the trial. Because with computers now that you all have, it is so easy to cut and paste and to move stuff around. There's no reason why you should have reserves for 6 months or 8 months or what have you. By that time, you've forgotten what it's all about. If you're going to start coming down hard on judges for unreasonable delays in trials, you have to understand the root cause of unreasonable delay. And you have, many very, very serious crimes going unpunished because, they weren't able to get it to court in time. But you look at the root causes for that delay, and you begin to realize it's the rules set up by the Supreme Court of Canada. And every so often they decide to clean house, and it just doesn't work. But I can't see where else they could go. There's some simple things like, if you look at the words of the Charter, they're simple enough. The Supreme Court of Canada, however, has set up so much jurisprudence with respect to almost each of those sections. That is, complying with it causes a lot of confusion and delay. I have to be careful how I say this, but I think that law is a fantastic profession. I love it. I always loved it. But there are too many lawyers, and there aren't many like quite a few of the people who graduate in law um, aren't able to get jobs. A few of them, usually the brightest and the best, go to the big firms, and the others start scrunching around. Criminal law is a nice area, but you don't make any money at it. So some of them go into family law, and that's fine. Some of them went into ICBC work, and that was lucrative. But it's cutting back. David Eby was talking about cutting back on that. That was a very lucrative area. And it's really tough. The graduates now have to decide that they have to go into the interior to practice. To say that you want to stay in Vancouver and make a living is becoming more and more difficult. With this modern era, you have to be careful what you say and how you say it. There's political correctness, and if you use the wrong adjective or what have you, you could find yourself with a lot of problems. The media is there ready to criticize. The Court of Appeal and the Supreme Court of there is there to pull your judgment apart. And I think that more and more people will have to do what I have always did. After I left the provincial court, I kept writing judgments all the time instead of giving oral judgments. You see, after being on the bench for quite a while and keeping up with the law as I tried to do, very often I could have given my decision off the bench, but I knew it was going to be scrutinized on appeal. So I found it was better to adjourn until the next day and type up something. And it's so easy to type it now because of the cut and paste, be able to cut and paste, sometimes even from the published reports to your judgment. If you can't get articles or you can't get a job in the lower mainland, head up to the interior. The possibilities in the interior are huge. You get into politics, you could do all kinds of other things. And I say this because I had to do it and I did it. You get in there, you do very, very well. Again, you could do practice, you could do a general practice, you could do ICBC work, you could do all of that sort of stuff. Become a member of a small community, you're a leader in the community, you get involved in all sorts of activities, and life, the quality of life could be a lot better than if you stay down in Vancouver and starve. The thing is that after you have established yourself in the interior, if you feel like it, it's not difficult to move down to Vancouver. But initially, look for the interior. I say get to the interior areas. There are places like Fort St. John and some of these places where they really need lawyers. And you don't have the Queenie, but how often do you go to the Queenie Elizabeth Theatre? And you make enough money to be able to take your trip somewhere else every winter or what have you it is. So I'll tell people don't be stuck in Vancouver. Vancouver is nice, but places like Kamloops, places like Prince George, of course the Okanagan is sought after, places like Prince George and what have you, look at it. Even Smithers, where I was, of course when I was there were just 2 lawyers. Now there are quite a few. But there are all these areas that are really nice places to live, and you could make a really good living and really make quite a contribution.